The Supreme Court today, in a landmark judgment, has allowed the amendment to the Hindu Succession Act in 2005 to be implemented retrospectively. Now that's quite a mouthful. Let me break down for you what it actually means. So in the year 2005, Parliament amended the Hindu Succession Act that governs how property is divided within the Hindu undivided family. As per this amendment, daughters were allowed to have equal rights. They were made coparceners in ancestral property. Now, who's a coparcener? A coparcener is someone who shares equally with others in inheritance. How do you become a coparcener? Well, by law, you become a coparcener just by being born. The same way that all sons are automatically, get inheritance from their family from the day that they're born. They have equal rights. Now, daughters were added to this. What was the confusion all of this time? Whether this act and this change comes into effect just from 9th September 2005 when the amendment was made, or does it also apply to cases from before? And here is where the Supreme Court has come in and made it very clear that it does apply to cases from before. So what are the main findings of the Supreme Court today, or the main rulings of the Supreme Court today? Let me take you through them very simply. Number one, Section 6 of the Hindu Succession Act confers status of coparcener on the daughter born on or before the amendment. That means this is for women not just born after 2005 but even before. These women all have rights to their ancestral property like their brothers do. Secondly, the rights can be claimed by daughters for any partition, that means division of property, which has also taken place before December 2004. Now, this is the crucial part, because so far the amendment was being interpreted as being valid only after December 2004 and for those cases. Now, that barrier has been removed. That means any case can technically come under this new act and fresh claims can be made. It's not necessary. Now, this is the important one, because there were cases where this question came up. It's not necessary that the daughter's father is alive as of 9th September 2005. Now, this is very crucial, because in one of the cases it was argued that since the father was no longer alive, his daughter's rights also got extinguished. The court has clarified that this is not the case at all. This is no longer a barrier. Then the daughters will be given a share in coparcenery equal to the sons pending proceedings or in an appeal. That means fresh appeals can be made. And the most important of them perhaps is that oral partitions will have to be scrutinized and backed with documentary evidence. Now, what do I mean over here? And this part's important, so please pay attention. By oral partition, a partition means a division in the family property. Ancestral property here is what counts. An oral partition means someone just said to someone that, hey, you will have this ancestral property, and everyone just agreed. Well, that will not necessarily stand up to scrutiny in court if challenged. There will have to be documentary evidence to back it. So, for example, tomorrow, a son cannot go to court and say that my father promised me that this ancestral property will belong to me and not my sister. His sister can challenge it, and the burden of proof will fall upon the brother to show that he indeed was given this property by some oral agreement. The Supreme Court also says that all pending litigation on this subject should be wrapped up and addressed in the next 6 months if possible. So now, what does this mean in real term? I have spoken to several legal experts to understand what the actual implications are. Does this mean that earlier cases can be opened up? Well, yes. Is it possible that if a daughter has been married several years ago into another family, she can now come back and say that, hey, I was not given my equal right in ancestral property? Yes, that can happen. If the daughter is no longer alive, can her son or daughter make that claim as a coparcener on the uncle? Yes, they can. What is the loophole for this? Because remember, there is always something that safeguards the other side as well in law. Well, one of them is if there is a clear will leaving said ancestral property to a specific person who happens to be the son, then that cannot be challenged in a court of law unless there are very specific conditions that are met. It will be that much tougher. What is also likely to happen is that maybe some business families where the succession battles are going on may dissolve their Hindu undivided families, draw up a fresh agreement where they say that all of the ancestral property, business, shares, etc. will go to a specific person who could happen to be the son, and everyone agrees to it, including the daughter. And this is where the cultural and social perspectives come in. Because even after 2005, there have been fairly few cases where daughters of the family have gone to court and have challenged the fact that ancestral property has gone straight to their brothers, bypassing them completely. It will take a lot of change in our society for more and more daughters to come forward, but if they choose to, at least the law will back them.